Dear learners, in the previous lecture, we were discussing the evolution of the concept of human rights, and we traced the origin of human rights in the non-Western tradition, in the religion-based tradition, faith-based traditions, in the civilizational values of the different countries or the different civilizations. We also talked about, the Magna Carta. We discussed what kind of achievements was there under Magna Carta. Then we also discussed the glorious Revolution of England of 1688 and the English Bill of Rights. Now, another important event in the history of humankind is the American War of Independence and the Declaration of Rights. As you all know that America was a colony, and in 1776 America declared its War of Independence. So the Declaration of Independence and the Virginia Declaration of Rights are considered significant milestones in human rights. So when we try to trace the journey of human rights, how it all started and how human rights evolved, then the American War of Independence and the Virginia Declaration of Rights cannot be ignored. Thomas Jefferson drafted the American Declaration of Independence. It contained the high ideals of the protection of life, liberty, and the pursuit of happiness, but they were clearly inadequate as a catalogue of rights that the state was obliged to protect. So the rights that we have today, these kind of rights were not mentioned. Rather, some ideals were mentioned in the Virginia, the Virginia Declaration of Rights. The Virginia Declaration was drafted by George Mason and included certain specific liberties like the freedom of the press, the free exercise of religion, and the obligation that no person should be deprived of their liberty except by the law of the land or the judgment of their peers. So from Thomas Jefferson, who drafted American Declaration of Independence, basically he emphasized on the ideals, but the rights were not there. Of course, certain ideals were there, very inspiring ideals. Here the Virginia Declaration was drafted by George Mason and included certain specific liberties like freedom of the press, the free exercise of religion, and the obligation of the state, of course, that no person should be deprived of their liberty except by the law of the land or the judgment of their peers. The Virginia Declaration greatly influenced the evolution and the subsequent incorporation of human rights in the US Constitution of 1787. Of course, that is Philadelphia Convention, you all remember how American Constitution was adopted, and the American Bill of Rights 1791. The successive constitutional amendments expanded the catalogue of human rights in the USA. You see, First Amendment, Second Amendment, many amendments were there in the Constitution of America. And when they amended their constitution, they included many rights. The horizon of the rights was expanded. And one of the most interesting thing is that the America has amended constitution, or many amendments were brought, or in the International Bill of Rights you will find many things were included, but no rights were deleted from the constitution. No rights were deleted from the 1791 American Bill of Rights. So that is quite interesting and quite encouraging as well. The US's Constitution and the Bill of Rights 1791 continue to inspire people across the globe to claim and reclaim human rights. So that is why it becomes a reference point. The American Bill of Rights or the American Constitution, it set an example, and that's why the American Constitution, the American Bill of Rights has inspired many constitutions of the world. Many constitutions, when the liquidation of colonies took place, and when the many countries got independence, they were inspired to include rights that were there in the Constitution of America or the American Bill of Rights in their respective constitution. So that is why it is a very significant contribution of American Bill of Rights as well as the American War of Independence. After American War of Independence, another important event or another important milestone is the French Revolution 1789. As you all know that the French Revolution is hailed as one of the greatest revolutions in the history of humankind. The slogans of liberty, equality and fraternity raised during the revolution still fascinate the people living under authoritarian regimes to claim their rights and liberties. You see that the Statue of Liberty, for example, wherever you will find that the Statue of Liberty that was inspired by the French Revolution. So in the French Revolution, what was there in the hands of unarmed masses? What was there? It was the slogan of liberty, equality and fraternity. So that is why it became quite inspiring slogans. And even today you will find that the people, when they are trying to fight against dictatorial monarchs, authoritarian regimes, military dictatorships, or whenever their rights are infringed upon by the state or by the authorities, then the French Revolution becomes a reference point. And we always quote, or the people always quote, right to life, liberty, equality, fraternity, etc. One of the greatest achievements of the French Revolution is that it provided a normative justification for claims of individuals to certain inalienable rights against a state. This is again very, very important. You see, rights are mostly claimed against the state, and that is why states are considered as major violators of human rights. But at the same time, you see that the present regime or the contemporary mechanism, instrument of human rights, when we see the responsibility of the implementation of human rights is of the states. In their territory, they are responsible for implementing the human rights norms. And that is why the states are held responsible for violating rights if they are infringing upon the rights of their own citizens. They cannot say it is our internal matter because they have agreed upon certain principles. And these principles, it means if they have signed agreements of the United Nations, treaties of the United Nations, if they have signed the conventions or the covenants that have been developed by the United Nations or the regional conventions or other conventions and the treaties, then it is their international obligation as well. Not only national obligation but international obligation as well to protect these rights. So if the normative justification that you find today, and when we try to provide legitimacy to the claim to rights, that is because of these revolutions. So one of the greatest achievements of French Revolution is that it provided what is called the normative justification to the claims of human beings to have certain rights, liberties and freedom. In the French Declaration of Rights of Man and Citizen, when we read, we find that the Declaration of the Rights of Man and Citizen, adopted in 1789 during the French Revolution, is a pivotal document that encapsulates the revolutionary spirit and aspiration of the time. This declaration enshrines the principle of liberty, asserting that all citizens are born free and have the right to participate in shaping their government. This is again very important. What is being emphasized? The principle of liberty, asserting that all citizens are born free and have the right to participate in shaping their government. So it means human beings are born free. Freedom is not something that is the gift of a state or the gift of society or the gift of a powerful individual. But the freedoms are natural. Liberty is natural. So all the people are born free. That is to be accepted. When the people are born free, it means they cannot be chained. You cannot impose unreasonable restriction upon the liberty and the freedom of the people. At the same time, what is being said, what is being emphasized? That the government it is being formed, it will not be a hereditary kind of government. It will not be hereditary monarchy. Rather, the people have a say in determining or in deciding what kind of government they want. Again, you'll find equality is championed. Equality is being emphasized, that the equal rights and opportunities of all citizens without distinction. So today, if the principle of non-discrimination is the integral part of all human rights treaties and declarations, again you will find that it is deeply rooted in these events, and that is why in this revolution what is being emphasized? Equality of all human beings. So the rights are to be given to the people without any discrimination on the basis of religion, caste, creed, sex, place of birth, economic status, etc. So they should be available to all the people. This is again is being emphasized in the French Revolution. Fraternity promotes a sense of solidarity and unity among the people, fostering a collective commitment to the common good. Again, that is important. That is fraternity. It means that today what we consider that violation of human rights in any part of the world is a threat to human rights in other parts of the world. So that is why human rights are to be protected. And if human rights is being violated in any part of the world, all human beings living in different countries of the world, they have every right to raise their voices. So that is fraternity, that is solidarity. And you all know that the solidarity rights have already been recognized in various treaties and the conventions of the United Nations and the regional conventions. When we see this Bill of Rights, we find, or the Declaration of Rights of Man and Citizen, in its preamble and its 17th article, it sets out the natural and inalienable rights, which are freedom, ownership, that is right to property, of course, security, resistance to oppression. It also recognizes equality before the law and the justice system, and affirms the principle of separation of powers. Article 1, it says, men are born and remain free and equal in rights. Social distinctions may be based only on considerations of the common good. So again, this is a very, very important right. What is being emphasized? That men are born and remain free. So the freedom is something that is natural. It is not the gift of a state or the society. And they remain free and equal in rights. So rights should be available to all the people without any distinction. Social distinctions may be based only on considerations of the common good. What does it mean? That, for example, if there are certain communities, certain groups, certain segments who are backward or who have suffered from what is called historical disadvantages, then of course the state can make certain laws, or the policy of rational discrimination or the positive discrimination can be adopted. It is being emphasized here. So that is why the reservation that has been given to us, given to the people in our country, for example, to the scheduled caste, to the scheduled tribe, to the OBC, or the economically weaker sections of society, they are justified. So that, this exception has been also accepted. Article 2 of this declaration says the aim of every political association is the preservation of the natural and imperceptible rights of man. These rights are liberty, property, safety, and resistance to oppression. So you see, these rights are being emphasized: right to liberty, right to property. People can own their property. It cannot be, state cannot take away those properties. Right to safety, and again very interesting, resistance to oppression. So whether the government is oppressive, whether a ruler is oppressive, or certain sections of society are trying to oppress other people, then the people have got a legitimate to resist. Right to resistance has been given. So that is why on the basis of Article 2, you can justify the national liberation struggles in the different parts of the world. The national liberation struggles against colonialism, imperialism, or occupation, whatever is there. Article 3, Article 3 says the principle of any sovereignty lies primarily in the nation. No corporate body, no individual may exercise any authority that does not expressly emanate from it. Again, important. So the sovereignty of the state has been recognized. It means a state is the supreme institution of humankind, and that is why other, for example, corporate body or some people, rich people, they are trying to gang up, they cannot exercise sovereignty. Why a state? Because the government that is formed in the state, that is representing the will of the public, will of the people, collective will of the people, collective wisdom of the people. So that is why the state will have sovereignty. So the corporate body, no individual may exercise any authority that does not expressly emanate from it. It means, the sovereign exercise of power should be there on behalf of the state only. And what is sovereignty? It means internally supreme and externally free. So, a state can make law, the legal sovereignty. Individuals cannot make law and impose upon others. Article 4, for example. Article 4 says, liberty consists in being able to do anything that does not harm others. Thus, the exercise of the natural rights of every man has no bounds other than those that ensure to the other members of society the enjoyment of these same rights. These bounds may be determined only by law. So it means that the rights or the liberty is should be given to all the people, and there cannot be any kind of a restriction upon the enjoyment of liberty of the individual so long as the individual is not harming others. It is not infringing upon the rights of others. So that is why there is only one restriction, that other individuals are not allowed to harm others. If they are not harming others, they have every right to enjoy their liberty and freedom. The only restriction that can be imposed upon the individual so far as the enjoyment of his or her liberty is concerned, that is that he or she cannot harm others. But these restrictions, when they are being imposed by the state, by the sovereign authority, you have to see that they are determined only by law. And law in a democratic country is made, or the legislation in a democratic country takes place with after a long discussion, deliberations, and the will of the public is always respected. So that is why this is very important. Article 5. The law has the right to forbid only those actions that are injurious to society. Nothing that is not forbidden by law may be hindered, and no one may be compelled to do what the law does not ordain. So it means that the law has the right to forbid only those actions that are injurious to society. So, you can have good law, you can have bad law. So any law that is trying to restrict the practices, actions, or the acts of the people which are not injurious to the society, these laws can be called bad law, and they should not be, they cannot be defended again on morally respectable ground. So that is why, this right also becomes important. Article 6, the law is the expression of the general will. All citizens have the right to take part personally or through their representatives in its making. It must be the same for all, whether it protects or punishes. All citizens, being equal in its eyes, shall be equally eligible to all high offices, public positions, and employments, according to their ability, and without other distinction than of their virtues and talents. Again, very, very important. You see, the law is the expression of the general will. It means law is representing the collective will of the people, and all citizens have the right to take part in lawmaking process, either through their representatives or directly. So in the direct democracy like Switzerland, the people directly participate in the lawmaking. But in democracies like India, France, Britain, USA, you will find that the people do not participate directly, they participate there through their representatives. So that is why it is trying to strengthen, establish and strengthen democracy. So the lawmaking power will be in the hands of the people. It is also talking about equality before the law. It must be the same for all, whether it protects or punishes, whether it is punitive action, whether it is punitive law, or whether it is dealing with the distributive justice, or it is trying to protect the people. All the laws should be same for all. All citizens being equal in its eyes shall be equally eligible to all high offices. Again, so it means right from peon to prime minister to president, these all offices must be open to all the people without any distinction, except merit or the ability, certain qualifications can be fixed, but it should be open to all. Article 7. No man may be accused, arrested, or detained except in the cases determined by the law and following the procedure that it has prescribed. Those who solicit, expedite, carry out, or cause to be carried out arbitrary orders must be punished. But any citizen summoned or apprehended by virtue of the law must give instant obedience. Resistance makes him guilty. So, the two important aspects we have to see in the Article 7. No man may be accused, arrested, or detained except in the cases determined by the law and following the procedure that it has prescribed. It means that, first of all, the principle of natural justice is also there here. An accused cannot be considered as guilty. So the presumption of innocence, that is being emphasized. So, for example, if a person is accused by police that he is a terrorist or he is a criminal or he is a dacoit or he is a rapist, what happens? That media trial starts and media starts giving judgment. This is violation of this particular principle. It is only law that will give the punishment, and the procedure is also there. At the same time, it is saying that if the people are accused, then what should happen? That when the people are accused, and if the law enforcement agencies are trying to nab them, arrest them, they should not resist it. Rather, they should follow the law. They should be law-abiding citizen. They should not resist. It means that you cannot violate the law of the land. So, for example, if the arrest is there for suspicion of a crime, then the persons cannot say that it is our natural right to resist. That will create problems. So that is why this has been also taken into account. Article 8. The law must prescribe only the punishments that are strictly and evidently necessary, and no one may be punished except by virtue of law drawn up and promulgated before the offense is committed and legally applied. So, of course, the law should declare that, if he is a criminal or not. Today, what happens? This is the reason, that is why you see that the encounters are most of the time criticized by the human rights organizations and the human rights bodies. Why? Because in the encounter, the accused does not get the right to a free and fair trial. The law enforcement agencies, they go for the encounters, and whether the encounters are real or fake, they are not encouraged by the human rights organization, and that's why the death penalty or even the encounters are most of the time criticized by all the human rights bodies. Again, Article 9, as every man is presumed innocent until he has been declared guilty. If it should be considered necessary to arrest him, any undue harshness that is not required to secure his person must be severely curbed by law. So, for example, if a person is not resisting, he is not trying to run away, and if the police is trying to commit any kind of atrocity, brutality, it is not allowed. Caning the person or injuring the person unnecessarily, it is not allowed, and it should, first of all, what is to be understand, that presumption of innocence, that is important. What is the job of the police? Police will arrest a person, and then the person will be brought before the court, and the court that will decide that whether the person is guilty or not. Police cannot, pronounce the judgment, and that is why police cannot commit this kind of atrocity. This is very important. So that is why, this separation of power that we see, the legislature, executive, and judiciary, these three important institutions of the government, they function, separately as well as independently, but at the same time, there is interdependence as well. Article 10. No one may be disturbed on account of his opinions, even religious ones, as long as the manifestation of such opinions does not interfere with the established law and order. So you see, this is what we call the freedom of conscience, which is being emphasized by human rights organizations, human rights activists, and the contemporary discourse accepted. So that is why no one may be disturbed on account of his opinions. It means that a particular kind of follower of a particular religion cannot be, targeted by others. So this is being emphasized. Article 11, the free communication of ideas and opinion is one of the most precious rights of man. Any citizen may therefore speak, write, and publish freely, except what is tantamount to the abuse of his liberty in the cases determined by law. Again, freedom of expression is being emphasized here. Article 12, to guarantee the rights of man and of the citizen, a public force is necessary. This force is therefore established for the benefit of all, not for the particular use of those to whom it is entrusted. So again, public force, for example, it may be police or anything. Article 13. For the maintenance of the public force and for administrative expenses, a general tax is indispensable. It must be equally distributed among all citizens in proportion to their ability to pay. Article 14, as you see, all citizens have the right to ascertain by themselves or through their representatives the need for a public tax. You see, right from Magna Carta to French Revolution, this is being emphasized. Article 15. Society has the right to ask a public official for an accounting of his administration. So that is accountable government. Democracy means accountable government, accountability towards public. Article 16. Any society in which no provision is made for granting rights or for the separation of powers has no constitution. Again, this is being said. So the constitution should be there, and rights should be incorporated in that constitution. Article 17. Since the right to property is inviolable and sacred, no one may be deprived thereof unless public necessity, legally ascertained, obviously requires it, and just and prior indemnity has been paid. You see, again, this is important. Why this right, the Article 17 is important. From here, dear learners, we will go to study the Marxist revolution and what kind of, socialist revolutions, what kind of contribution they have given to the catalog of rights. You see, Article 17 of this, Declaration of Rights of Man and Citizen, it is talking about the right to property is sacrosanct. So the right to property cannot be taken away. So that is why the French Revolution, from bourgeois revolution, Magna Carta to the French Revolution, these revolutions are sometimes criticized as bourgeois revolutions, as they are providing right to property or right to private property. You will find in the next lecture that in the socialist revolution, you will find that private property is something that is denounced. People don't have right to private property. And that is why the property is something that you'll find the socialist scholars or thinkers, they will say that there should be abolition of private property. So therefore, these revolutions from Magna Carta to the French Bill of Rights, you'll find what has happened, that right to life, right to liberty, right to property, these rights have been emphasized. And that is why the catalog of rights, that, for example, civil and political rights, in all these, events, or in all these great revolutions from Magna Carta to the glorious revolution of England, or to the American War of Independence, or to the French Revolution, what have been emphasized civil and political rights, and that is why these rights are called first generation human rights. After this, we will take up what is called the second generation human rights, and that we will be dealing in the next lecture. Thank you very much.